Now let's get some perspective on what former President Jacob Zuma faces this weekend as he tries to avoid jail time. My colleague and eNCA anchor Thulasizwe Simelane has covered the comings and goings of Zuma extensively over the past few years. Thulasizwe, thank you very much for your time on a weekend. Now, the president, obviously yesterday, those court papers that were filed, a lot of people would say this is a delaying tactic.
Well, for me, it's a change of tactic more than anything, Masejo. We've gone from statements that are issued in the public domain, that can go in any direction, that have no bounds. He can freely express himself. I mean, the one line I remember from one of the statements was, "Let their law take its course," and basically him saying that Justice Raymond Zondo has rushed to his subordinates to, get an order that he knows he will get, definitely an order for the incarceration of the former president. We've gone from those to now him being on the record, but a tad too late, because the record is actually closed in as far as the matter between him and the Commission of Inquiry is concerned formally inside in the courts. So, I mean, he's invoking a Rule 42 of the Uniform Rules of Court, which is incorporated into the rules of the Constitutional Court by Rule 29 of the Constitutional Court rules. Basically, this has to do with rescinding an order that was, importantly, erroneously sought and granted in the absence of one of the parties. So if there was an application and, you were not aware that there was this application on the go, and the court, erroneously in that sense granted this application against you, this is invoked. But in this case, in the judgment of the Constitutional Court of Sisigampepe of the last few days, they go to great lengths to say that it's impossible for him to say he was not aware that this order was granted against him. Firstly, the order from the December application, which was granted at the end of January, but also, the affidavits and the papers filed when the Commission of Inquiry was seeking this order of incarceration for contempt of court. In all instances, he was aware. In fact, they say that when the Commission of Inquiry was filing its application and its papers in the contempt of court matter, they attached to their founding affidavits the order of the Constitutional Court, which had said he must appear at the commission. So they're saying that it's unthinkable that he wasn't aware that this application was on the go. But you and I can talk about the interesting arguments that he then raises as potential errors that he says the Constitutional Court made, that he says basically on the basis of those errors, I think you should rescind your order.
And his application goes back to the High Court specifically in two parts. But the former president, had he actually filed these papers, some of the reasons that he gives in the papers he filed yesterday are actually valid reasons. For instance, saying that he doesn't want the case in the Constitutional Court, the contempt of court case, to continue because he's still awaiting the fact that he has taken back the case of the recusal of Deputy Justice Raymond Zondo to take him off, to actually recuse himself from the commission. He could have given those reasons. He could have given the reasons he gave about being too old and frail health-wise to spend time in prison. But he decided not to file these papers.
Yeah, absolutely. I wouldn't go as far as to, make up my mind whether they're valid or not, the reasons. But they certainly would have exercised the minds of the Constitutional Court justices, as well as the other side that was arguing on behalf of the Zondo Commission. There certainly would have been many, many debates that are raised. For instance, the arguments that he makes about the Deputy Chief Justice and the Commission of Inquiry in seeking to enforce and ensure that he appears before it, them not going the route of the Commissions Act, processes, charges along those lines to say, you were supposed to cooperate with a Commission of Inquiry duly established, you have failed, and therefore we are laying charges against you, as had been announced by the DCJ at some point during the proceedings. he could have made those arguments, because he's saying one of the errors that he's now arguing is that the Constitutional Court erred in granting an order in a situation where the DCJ basically followed a path that he should not have followed. The path that Mr. Zuma says the DCJ and the Commission of Inquiry should have followed is the path of the Commissions Act, laying charges and saying this person has failed to comply with a summons to appear before a Commission of Inquiry, and therefore they should be charged under the Commissions Act, which is the similar line that was followed in the matter, the well-publicized matter around P.W. Botha not cooperating with the Truth and Reconciliation Commission. There could have been an argument there to say, why are you going directly to the Constitutional Court? And he goes to great lengths in that argument in the papers that he has now filed. One of the things that is interesting that he says, Masego, for example, is the whole thing, one of the most interesting paragraphs for me was him talking about he had no money. He says finances have become difficult, and therefore, he's giving reasons why he did not participate in the application in December and the application in March, and says he started prioritizing his criminal trial. And therefore, on the advice that he had received at the time, he was told, no, there's no way that the commission will get the order that they are seeking at the Constitutional Court, because, the Constitutional Court will send them packing and say, go invoke the Commissions Act and follow that route. And even on the issue of contempt of court, he says basically that was the prioritization that he was now making. These are all interesting arguments. I think, Masego, that there appears to me to have been a change of tactic. That initially the tactic was, or perhaps the reading, a strategic reading in Mr. Zuma's camp, was the anticipation that DCJ Zondo would go the route of laying charges through the Commissions Act processes, which charges would likely take, a very long time to come to fruition, as we are seeing right now. That he would then go to the highest court in the land and try and seek his cooperation initially, but also even for the punitive order, he would go directly to the apex court. I don't think that was anticipated. Hence, you are seeing this change of tactic now, which, as I say, is a tad too late.
That money argument or finances argument is very interesting, because we did have a ruling in one of our courts in South Africa that said that the former president should actually pay the state back for some of the cases that he took to court. And had he still been able to have access to state money, probably we would have seen him in court. But also, Thulasizwe, I want to talk specifically about him not filing these papers. It's not the first time that he hasn't done this. I mean, he was an applicant, in fact, in the state of capture report by the public protector, which was also recently thrown out of court with punitive cost against the president. Even there, even more strange, he's the applicant, but he doesn't file his heads of argument.
Yeah, look, he says in the papers that he has now filed, two applications that he has filed. One is for a stay of execution of the order of imprisonment. That's in the High Court Division in KwaZulu-Natal in Pietermaritzburg. The second one is before the Constitutional Court, the Rule 42 based application for the Constitutional Court to basically reconsider, rethink, and rescind its own order. Therein, he reveals that he has been the subject of 12 cost orders amounting to 20 million rand. And basically, he says at this particular point, also he was affected by the change of legal teams, and that sort of had its own impact. He had to find new legal teams, and that on its own was not easy, because he's now having to tell people that, listen, represent me. I will raise the funds to be able to, to be able to pay you. These are some of the arguments that he's raising as to why he did not file some of the responding affidavits. He says in some of the matters involving the Commission of Inquiry, he simply did not participate because, the monies were just not there, and he was prioritizing his criminal trial. I suspect that, at the time when he was still represented, certainly by the previous legal team, those arguments could have been put on the table before the Constitutional Court and they were not put before the Constitutional Court. He makes a lot out of what the minority judgment in this week's Constitutional Court outcome raises about, this whole idea of sending a person to prison for contempt of court when there's not been a criminal trial. So you remember that the Constitutional Court majority judgment says these proceedings are neither civil nor criminal in nature. They're sui generis. They are an amalgamation, a fusion of sorts of the two, in that the procedure is civil, but it can have a criminal element in that you can be sent to prison for contempt of court. So what it's trying to do now is convince the Constitutional Court that one of the errors they made is basically not considering the unfairness in a constitutional scheme of treating civil contempt differently from criminal contempt, because he says had there been a criminal trial, he would have been able to raise all these defenses about why he did not file affidavits, about why he walked out of the Zondo Commission. By the way, he says it didn't work out. He simply had to go and take his medication, and also he believed that he was free to leave. And the next thing he says, to his surprise, he heard DCJ Zondo saying he had left without permission. All of those arguments, he says, he could have raised had there been a criminal trial, as opposed to the criminal sanction, the sanction of imprisonment flowing from what the court has described as sui generis, a fusion of civil and criminal proceedings.
And also part of that argument, Thulasizwe, correct me if I'm wrong, is that the former president also wants the courts to look at the constitutionality around the law of a case that has to do with contempt.
Yeah, absolutely. So he says people who are found to be in civil contempt as opposed to criminal contempt are treated differently in that they don't get the vigorous processes of a criminal trial that are prescribed by the Criminal Procedure Act, where you can call your witnesses, where you can adduce evidence to show that actually I'm not in contempt of court. But he says in this particular case, because there was the civil, this whole matter was decided on a motion application. A motion application is usually where there's no, the case is decided mainly based on the papers that are filed and the arguments that are then presented. And usually there's not much of a dispute in terms of the facts. So he says those people who then happen to be found to be in civil contempt are treated differently in a way that is not allowable within the constitutional scheme. But there's another interesting argument. I mean, he throws everything but the kitchen sink at these arguments now, Masego. One of the arguments is that he's being treated, unfairly in terms of the equality clause of the Constitution, which is Section 9 of the Constitution, and the basis for him being treated unfairly and not being allowed equality of the law, equality before the law, and being treated equally by the law is based on solely on him having been the president of the republic, and is saying that that is not something that should be allowed to happen in our constitutional scheme. Again, as I say, these are arguments that I think would have taken a bit of time in the Constitutional Court, with proper responses from the Zondo Commission team and the justices quizzing them and interrogating them. But they were not afforded that opportunity. And lastly, Masego, interestingly, there's this line where he seems now to be disavowing almost altogether these statements that were part of the basis for the Constitutional Court saying that, your contempt is so egregious that we need to actually deal with it and set an example that, no one should go in this direction. The words that he uses there, he says one of the errors that the ConCourt is making, that is the basis for him wanting them to rescind their order, is that they are erroneously assuming or concluding that the statements were made by him. All the statements we've been seeing, he says, the ConCourt is erroneously assuming or concluding that they were made by him. So in a way, all the statements we've been saying, former President Jacob Zuma says, the judiciary is being used to fight, all of that, he's now seeking to say, I didn't make those statements.
Very strange, and I want to talk specifically about those statements, Thulasizwe. I mean, you've covered the former president extensively through your time as a political journalist, and you've gone to so many of his court cases. One of them, of course, with Thales, that criminal court case that is at the Pietermaritzburg High Court. In this application of rescindment that he actually filed yesterday, the former president goes back to using the languages of, I'm sorry if I annoyed you, it seems as though, and I'm paraphrasing right now, but he says it seems as though this decision by the Constitutional Court is taken by people who are irritated by some of the statements that were made, even though he says they were not his statements. This is very similar to what he's done, for instance, with that 21-page letter that he filed instead of arguments. And then what he's saying in the court in Pietermaritzburg about Billy Downer stepping down. He keeps saying that, there are people who are biased against him, and there are people in the law who have forgotten their constitutional obligation and are part of political battles. He wants to be seen as the victim.
Yeah, so there is a sense in which, though, there's a bit of contrition. Well, it's certainly the language is slightly less, aggressive, or the tone is slightly different from the public statements. For instance, the court is addressed as this honorable court in a number of instances. This is a far cry from a man who was saying they can expect no cooperation from me. Let their law take its course. Clearly, they've made up their minds. These judges are playing in the political arena. The tone here is slightly different. It's this honorable court, and he is urging this honorable court to, dig deep into its sense of fairness and upholding of the, of its constitutional role. In a way, now there's a degree of confidence in these courts, which the public statements had basically said he has absolutely no confidence. And as I say, he's now seeking to disavow the public statements, certainly in the application for a rescission of the Constitutional Court order. It's part of the other difficulty, Masiko, that we must point out from a law perspective that he does raise, which, again, I say, could have made an interesting argument, certainly in the contempt of court application, is that the statements that are used to show the extent or, how egregious the contempt is, certainly the court arriving at a conclusion that the statements are of no value as to determining whether or not he's in contempt of court, but their only value comes in aggravation, to say, actually, this is aggravated contempt of court. He now wants to argue that it was a mistake for those statements to be admitted as, hearsay evidence. Certainly now, given that he's now saying that the court erroneously assumed or concluded that those statements were made by him. He wants to challenge that hearsay evidence being admitted in that aggravation of this contempt. I suspect all of that, when at the point at which they had said to him in April, for example, that give us a 15-page affidavit addressing why, addressing what sentence would be appropriate if we are to find you are in contempt of court. That's the point at which this could have been raised. But interestingly, even on that affidavit, call for an affidavit by the Constitutional Court, he says he found it strange that he was being asked to almost say something in mitigation of sentence before a conclusion had been made on whether or not he's guilty of the crime of contempt. So these are all interesting arguments, but I do believe that actually they've come a tad too late. The key now for him is to convince the Constitutional Court that the order for him to be incarcerated was granted erroneously. And I don't know where the error is. He points out a number of errors. For example, he says their failure to invoke Section 36 of the Constitution in limiting his rights is an error. the Constitutional Court dealt with the issue of Section 36 and said it doesn't even arise, this whole debate about his rights being limited in the way that, is required by Section 36. He could have made those arguments. His advocates could have made those arguments in the ConCourt.